Welcome to Clue, Criminal Law for UK Enforcement. If someone walks into a shop and doesn't steal anything, is that still burglary? Surprisingly, yes. In UK law, burglary isn't just about stealing. It's about trespass, intent, and where a person goes. Even stepping into the wrong room with the wrong motive can trigger the offence. Let's break it down clearly, the Clue UK way. Real-life question. What if the person never steals, breaks, or hurts anyone? Can they still be arrested for burglary? Yes. Under UK law, burglary can happen the moment someone enters a building as a trespasser if they intended to commit certain crimes. Let's find out how. Let's look at the first definition of burglary. Section 9, subsection 1A of the Theft Act 1968. A person is guilty of burglary if they enter a building, or part of one, as a trespasser, with intent to steal, inflict GBH, or cause unlawful damage. This version is about what they planned at the point of entry, even if nothing was taken or broken. Let's look at the second definition of burglary, Section 9, subsection 1B of the Theft Act 1968. It says, a person commits burglary if, having entered a building or part of it as a trespasser, they then steal or attempt to steal or inflict or attempt to inflict GBH on someone inside. This form of burglary focuses on what they did after getting inside, rather than their original intent. Differences explained. Picture a shop floor plan. The front is open to customers, the back stockroom is staff only. Under Section 9(1)(a), if someone enters the stockroom as a trespasser intending to steal, damage, or harm, that's burglary. Under 9(1)(b), if they enter without clear intent but later steal or cause GBH, it still counts. 9(1)(a) equals intent at entry. 9(1)(b) equals action after entry. Let's explain the key terms. First, it's entry. Entry doesn't mean someone has to walk fully through a doorway. Even if just their arm, leg, or head enters unlawfully, it counts. In R v Ryan, 1996, a burglar got stuck in a window and couldn't move, but was still convicted. This is the physical element of the offense, also known as the actus reus. Watch our Clue UK video on actus reus to learn more. Trespasser. Trespass in burglary means entering without permission. Even in a public place like a shop, a person might have access to the shopping area, but not the staff room, stockroom, or office. Once they step beyond public access, with no lawful right to be there, they become a trespasser. And if criminal intent exists, burglary begins. Intent. Burglary under 9(1)(a) depends on intent, the plan to commit theft, GBH, or damage at entry. Intent is the mental element of a crime, known as mens rea. Find out how intent is proven in our Clue UK video on mens rea in real-life cases. Even if nothing is taken, if the intent was present, that's enough for conviction. Building. The term building includes homes, sheds, garages, shops, and even locked or private areas within a larger building. Note, the structure must have 4 walls and a roof. The building must have some degree of permanence. Tents and temporary shelters usually don't count. Courts consider structure, use, and intended purpose. Even a locked freezer container used for storage counts. Aggravated burglary. Remember wife. When someone commits burglary while carrying a weapon, it becomes aggravated burglary under Section 10 of the Theft Act. Use the acronym WIFE to remember what counts. Weapon of offense, imitation firearm, explosive. If any of these are present during the burglary, the charge becomes much more serious, with a maximum sentence of life imprisonment. Legal defenses. A person may have a defense if they had lawful permission to enter. They lacked intent to steal or cause harm. They acted under duress. Someone made you do it. Claiming nothing was taken is not a defense if criminal intent at entry can be proven. The law looks at both mental and physical elements, intent and action. Case law, R versus Ryan, 1996. In R versus Ryan, the defendant became stuck while trying to crawl through a window. His head and arm made it inside, but he couldn't steal anything or move. Still, the court ruled that entry had occurred and he was guilty of burglary. Why? Because intent and partial entry were enough, even without a successful theft. Because we mentioned this case earlier, here is another. B&S versus Lefley. In B&S versus Lefley, a man broke into a massive freezer container parked on a farm. It had power, hadn't moved in years, and was used for storage. His defense? It's not a building. But the court disagreed. They said it was, because it was fixed, used like a building, and not temporary. It set the rule. Even containers can count in burglary if they act like permanent buildings. Recap. Section 9(1)(a) is about intent at entry. Section 9(1)(b) is about what happens after entry. Aggravated burglary involves the person bringing their wife, weapon of offense, imitation firearm, explosive. Trespassing means entering where a person has no right to be. Intent matters, and so does even partial entry. Thanks for watching. If there's a legal topic you'd like us to break down, drop a line in the comment section below. We're here to make the law clear, practical, and easy to understand. If this helped, give it a like and hit the subscribe button. Stay tuned for more videos. Keep learning, keep overstanding. Know the law, understand the offense. See you next time.